Say we're good to go?
Now declare this hearing to be in session. We are here to continue case number BOA 25060221, Brian and Sharon Lifford. We'll now hear from, let me do this first. All that wish to testify, please stand and take the following oath. Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give will be the whole truth and nothing but the truth?
I do.
Mrs. Maxwell, have all postings and notification requirements been satisfied?
Yes.
And any matters related to jurisdiction of this board will now be heard. Let the record show there were none. Department of Planning and Zoning now be heard.
Good evening. Robert Owen, Zoning Inspector for Queen Anne's County. The variance requested for Brian and Sharon Lipford is to reduce the required 35-foot front yard setback from Cedar Road to 20 feet to construct a two-story single-family dwelling, including a garage, covered porch, and deck. The following code, 18-1-19E 1C4FI, is requiring a 35-foot setback and building restriction line that is established and required within the Neighborhood Conservation 20 zoning district that this property is in. On this slide, in the black outline, is the parcel in question. It's tax map 57, parcel 378, lot 9. It totals 0.757 acres and is located on the corner of Benton Pleasure Road and Cedar Road. And then on this map here is showing the neighborhood conservation 20 for what it is in, which requires the 35-foot setback. Further layers from the county map it is in the LDA critical area with floodplain along the shoreline and hydric soils on the property, which are shown in the boxed hash mark in the neon green. There are tidal wetlands that protrude onto the parcel from Cox Creek, which is the almost baby blue color coming in from the water. This is Lot 9 was created in 1947 when the lot width was permitted to be 70 feet and then changed to 100 feet width in 1970, making this lot currently a legally non-conforming lot. On this slide, you can see here the 100-foot shoreline buffer that is required on this lot in the light blue hash marks, as well as the yellow dash line, which denotes the current building restriction area located on the parcel.
What is that side yard restriction on the south side there? Or what's the setback on the side yard?
If I remember right, it's
7.
It's usually 7 or 8.
That's what I thought. I just want to get that on the record, because if this wasn't a 2 front yard plot and this were a side yard, it would be 7 feet.
Yes, that's correct. This is the applicant's exhibit and site plan that was submitted with BR 2503-0181, which is their building permit. And then on this slide, you can see the applicant proposes a 20-foot setback variance to have a single-family dwelling with deck going to the 20-foot mark from the southern corner of the deck, butting up to the 100-foot buffer. So the corner of the deck would be exactly on the 100-foot buffer, and the garage would stay within the 35-foot build restriction line. That is the zoning's case for this.
Anything else?
Zoning staff has no objections to the approval of the variance, and the applicant must present clear evidence of practical difficulty.
Y'all have any questions?
No.
Mr. Stevens?
Thank you. Good evening, board members. Joseph Stevens on behalf of the Lipfords. And I just want to do a couple of preliminary matters first. First, as far as the multitudes of variances I've taken to this board, I mean, falls squarely into the categories of those variances that the variance law recognizes, land use law recognizes. We have a peculiar property, very long and narrow, created actually before the zoning was in place in 1947. There wasn't zoning yet. It came in 1964. I'll provide you a copy of the 1947 plat, so you have that for the record.
Sir?
Identifying the site. And it is abutted on two sides by a road, so it gets squeezed very tightly in regards to its ability to construct any reasonable improvement on the property. So
We're going to go ahead and
Let me start again here. We're gonna enter exhibit 1 through 7.
Thank you, yes, no
and then I'm
objection.
going to label this as applicant exhibit 8.
8.
Okay, and then we'll go from there. So it's abuts two roads, and those two roads on a very long and narrow lot, over 400 feet long and only 70 foot wide, create a disproportionate impact of the zoning regulation of 35 feet from each road on this property. We will have further testimony from the architect as to, this is very much in line with what else is in the neighborhood from a size standpoint. We're not going to be in the buffer. We're not impacting any hydric soils. We're not going to be impacting any non-tidal wetlands. So it's completely compliant with critical areas. Our only issue is the two front yard setbacks that we have on this property, and that, we believe, falls squarely into variance law. I do want to give the Board of Appeals a copy of a administrative subdivision, just for the record, so that there's no question. There was an administrative subdivision done back a few years ago, 2021, on the lots to the south. It included this lot, but this lot did not change. So has never been a change to the size of this lot since 1947. So I want that in the record for the board. Thank you.
We're going to enter this as applicant exhibit 9.
Yeah.
With that, I think I'll call my first witness, which is Michael Dolce. Come on up, Michael. Mr. Dolce, could you identify yourself for the board?
Michael Dulce.
Sorry.
I-
Yours isn't the first nor the last
That's
that I will get wrong this evening. Could you identify your background for the board?
Sure. I have been working in the construction industry over 35 years. I became a licensed architect in 1991. I obtained a Maryland architecture license in 2005 and established my own Maryland-based design firm shortly thereafter. 85% of my work is in the residential design area, a mix of custom homes, additions, and remodel work.
And you were hired by Brian and Sharon Lipford to do what?
I was hired by them to design a custom home for this subject parcel.
So the subject parcel is identified as, on the tax records, as 209 Cedar Road, Chester, Maryland. Is that correct?
Yes,
Okay, and there's a copy of the tax records identifying that address?
Yes,
Okay, and is that a copy of the tax plat showing the location of the property?
yes, it is.
Number 9, right?
Mhm. Yep,
Okay,
right there.
I'm going to give that to the board as the next exhibit.
What is this, Joe?
That would be number 10?
No, what is the,
Oh, it is the tax property ID from the Queen Anne's County Property ID. noting the address, location of the property. All right, go ahead, Michael.
Be number 10.
Yeah, applicant 10.
Okay. Yeah, so I was hired to design this home for this parcel, and you know, basically the idea is the home was to be a place they can retire to, allow their children to visit, allow them to enjoy their hobbies, have access to the water. They've also made provisions to house an elderly parent temporarily if needed, with some aging in place features, first floor bedroom, et cetera. This, I wanted to get into
Yeah,
this.
go ahead, yeah. Please,
Okay.
please describe the property a
Sure.
little more for the board.
This property is unique and narrow. It's a 70-foot width and approximately 482-foot wide at its longest point, 3/4 of an acre in area. As we mentioned, the 70-foot plot width is a pre-existing non-conforming condition, in that the minimum lot width in the zoning district is 100-foot. There is a gravel paved road within a 30-foot public right-of-way along the north side of the property, which it contains the dead-end extension of Cedar Road. This portion of the road only provides access to the 3 properties abutting it. And the required 35-foot building relief line from this right-of-way is the one that has disproportionate impact on the lot, and it's greatly limiting the development on this site compared to similar plots in the area. This restriction is limiting us to a 27-foot wide building footprint, whereas similar lots with a conforming width and compliant building relief lines would allow for more in the neighborhood of a 50-foot building width. The uniqueness of this property is not the result of anything the Lipfords had done. They had purchased this property as is, have not sought any previous zoning modifications to it. In designing a home on this lot, the clients wished to design a modest home in proportion to most of the homes in the area, so we were trying to limit the square footage to 2,800 square foot living area.
Am I showing you a architectural rendering of the home as designed?
That is our proposed home for the site,
I'll
yes.
provide that to the Board of Appeals. Number 11.
Yes.
Go ahead.
So, again, targeting a 2,800 square foot home, we immediately ran into challenges trying to create functional layouts and maximize the water views. The narrow allowable building envelope, due to this building relief line, could only lead to a narrow, elongated home design that would not be able to best take advantage of the site's best features. As an example, instead of having, a great room stretched out along the waterfront, kitchen, dining, living areas, we'd now have to reconfigure that into more of an L configuration. As the home became squeezed into this 27-foot width, the configuration creates narrow rooms and long corridors. And due to this elongated shape, we would need additional circulation space and floor area to make the layout work. And this is typical of long, narrow homes, which can require more floor area, more exterior surface area, which can increase cost compared to similar, more proportional designs.
Would it also increase lot coverage as well?
Yes, it would.
Is this a comparison of the two, the existing, what's proposed before the board with the variance, and if you were forced to create a long, narrow home without the variance?
Yes, that is.
This is a plot plan showing the two differences between the two types, so that would be number 12.
And is this assuming the exact same square footage, or is this accounting for additional square footage because it's long and?
It's accounting for the additional square footage and accommodating the layout to create a similar layout.
Okay, go ahead, please.
So, so the other factor, due to that 35-foot line, we'd be required to make the layouts work, we'd be right up against that setback or as close as possible. So that would limit us from doing a covered porch beyond that or setting the garage back, features that are normally sought after in a street-facing facade. So this would limit us and not allow us to do those types of things. The home as proposed would be outside, as mentioned, the 100-foot critical area. We're proposing to hold it a foot away to the corner of the deck, and then on the angle, it improves beyond that. We would meet every other building relief line. We'd meet the maximum height requirement and the building coverage requirement. And the construction of the home would pose no environmental impacts beyond what is normal in standard home construction. Excuse me. We believe reducing this 35-foot required setback to 20 feet is more appropriate for this narrow, non-conforming site, as demonstrated in that comparison we had submitted.
Why is that?
Well, I mean, it's creating, if we're forced into that particular envelope, you could see that the differences are more square footage, a longer home. What else here? Yeah, longer, larger structure would be required.
And could be constructed without a variance.
Exactly, yeah. I mean, we could build a house 27 foot wide by 147 feet long under those current restrictions and meet our coverage and everything else. I mean, it's not an ideal design, but it under that current.
Would the design, the second design that you showed, which is, roughly the same functional house, larger square footage, because you said, you testified as to why it would need to be, same functional house, in your estimation, does that have a greater or lesser impact visually from other properties nearby, including from the road?
Yeah, well, of course, it would have a greater impact, potentially blocking views as it, picturing and extracting along that yellow line more towards the street. So view corridors would potentially be blocked and so forth. Besides the fact that the design will be essentially a flat facade. It's not able to, again, get that undulation or variation on the.
You said that you had an opportunity to evaluate other properties nearby and to do a comparison of the square footage of homes nearby to show that the square footage of this home is very typical, falls right in line with square footages of other homes nearby. Is that accurate?
That's correct, yes.
And am I showing you your evaluation, what you did?
Yeah, those are the parcels I
Okay.
used in the immediate
You don't need
vicinity.
to go through each one for the board, but I'd like you to give the board number 13.
Yep, we're up to 13.
13.
This is the assessment that Michael has done. I'd like you to give the board just a quick overview of that assessment, if you would, and what your conclusions are.
Yeah, so what I did is I drew a radius around the property. I forget exactly what the dimension was, but I took homes and then based on available public tax map information, which publicly shows the homes areas, et cetera. I have a chart somewhere, actually. I put together a chart.
Charts, right after this.
Oh, okay,
There you
yeah,
go.
so I
This
have
is
it here
Page
too.
2. Okay.
Sure. So I basically did a spreadsheet, put the listed living areas based on tax records, and computated the average of those homes. Average living area of all the homes in that area, essentially 2,700 square feet, and then just looking at the waterfront homes, the average of the home size is, again, this is living area, 2,900 to 3,000 square feet. And I'm not sure if we had submitted that, but
I just did.
Yeah,
They're both
okay.
submitted. Okay.
so that's how that was established, and that's how we wanted to keep our home in those kind of similar proportions.
And do you think that the variance request is the minimal needed in terms of the amount of variance in order to achieve a home that is consistent with those homes in the neighborhood and able to be designed to function properly?
Yes, I think that's, we wanted to go with the 20-foot number. I mean, ideally, we'd reduce that even more to get some more design features to the home, but we felt that was a reasonable ask in proportion to what the width of this site is and the context of the neighborhood and so forth.
I want to go back to one other thing. You had mentioned Cedar Road. Cedar Road, as you know, is public on the, we'll call it the east side of Benton's Pleasure Road, but as far as you know, it's a private right-of-way on the west. Is that correct? So on this side, it's not in the county's road system, is what I'm asking you. This is not in the county road system, correct? Well, do you know? If you don't know.
I assumed it was public right away.
No. No, it's not. I'll testify to that. It's
Yeah,
not. I checked with Public Works. It's a private platted road in this subdivision. Public-
lane.
Just a lane. Public Works is not taking it over. So I just want to make that clear.
Okay, sure.
Is there anything else you'd like to add?
I mean, just that I don't feel this home as proposed would have really any adverse effects on the neighboring properties. Even with the variance being granted, we'd still be significant distances from neighboring homes. I think it's about 145 foot to the first home on the north. We'd be placing the home 245 feet from Benton's Pleasure Road, so there'll be really minimal visual impact from that part of the street. And, I really believe it would only have positive impacts by allowing us to create a more attractive design that's in proper scale and size to the surrounding homes.
Putting aside the exterior aspect of it, the attractiveness and the larger footprint, what would be the impact on the interior usability and goals of this house that they're building if you had to go with the longer, narrower one?
Right, yeah. So
Because
that's
what you've given us is arguably a viable option, so what makes it not
right,
viable?
so it's not an ideal option, but, so some of the rooms, like for example, we have the workable building envelope is 27 feet. So you take away the thickness of exterior walls, now you're 26 feet. You take away the thickness of interior wall. Picture a double-loaded corridor, bedroom, hallway, bedroom. You're going to end up with maybe 10-foot wide bedrooms flanked by a hall space, and 10 foot by, in a home this size, 10 foot is not an ideal. We're trying to get 12-foot minimum for a reasonable bedroom to get furniture and a queen-size bed and so forth. So once we're dealing with that type of situation, it's kind of, again, and that's why it's elongating the home, because we still want that square footage to kind of meet our targets and so forth.
Would there be impact on accessibility? One of the things that was mentioned was a first-floor bedroom for the purposes of an elderly family member and the builders down the line. Does that impact the usability of that first-floor bedroom from that perspective and standpoint?
Possibly, yeah, because again, the same thing, when you create these spaces, especially for usability, we're doing wider doors and so forth, so potentially a wheelchair could wheel through, so we do a minimum 34-inch wide doors. So same thing, that bedroom, if being a 10-foot bedroom, now trying to maneuver wheelchairs, it limits how we can do that.
A 10-foot, I'm sorry, go ahead.
Yeah.
I mean, a 10-foot bedroom, you wouldn't design a typical house with a 10-foot
No,
bedroom.
again, I always use 12 foot as our minimum and go from there, hopefully get more than that, but.
I have a question for you. On, you testified to the minimum width being 27 foot to maintain it within the required setbacks. On the house, and then on Exhibit 13, where you evaluate other homes and stuff, how many of those, or did you evaluate the width and length of those? How many of those were 27 foot or less?
I know I did look at that. I have to kind of refer to my chart here again. I don't think I came up with many. There were maybe, I'm seeing one here that's 47 by 28 feet. Another that's 66 by 30 feet. So that's 2 out of the, more than a dozen homes here that approach that narrowness or that proportion.
Would either one of those still would not be compliant without a setback, correct, variance?
Correct, yeah. So those would not fit within that.
Or they might have predated the zoning.
Right.
Yeah, I'm not sure I don't know what the particular cases. In fact, that house might be rotated in the other direction even.
You didn't find any house that one of the dimensions is 27 feet in that?
I did not in my scan, again, of these adjacent properties within I forget what that radius is exactly, but.
Anything else for Mr.?
The orange in back of the dwelling there with the lawns, is that hydric soil?
Are you,
Oh, that's
on
the,
that- on
that's the
that
deck.
slide, Sir, Mr. Dean, that is the deck with the orange slash lines.
That's what?
That is the deck on that.
Oh, that's a deck?
Yes, that's a
Oh, I
deck.
see it now. How close to the hydric soils is the deck? How far away?
We were proposing a minimum of a foot to the cantilever edge of that corner of the deck, and the footings will be set in another foot. And then, of course, you can see visually that line tapers away, so it kind of improves our separation as it goes to the north there.
That's the setback line, right? The hydric soils were
The
inside.
blue line, blue and yellow line.
It's the blue and yellow is the setback lines, the 100-foot critical area buffer. I can go back in slides. So the hydric soils actually come in, from what it appears,
Well-
in towards where the deck is,
I-
without it being imposed on this
Yeah,
slide.
I can address that even further. The previous owner who did the subdivision that didn't in fact affect this, did a hydric soils report, and I can put this into the record. But if you look at, they didn't actually, went out there on site, because when things get this close, the department requires you to go out on site and determine where the hydric soils are actually at. This is just a map, it's, based on aerial photography and so on. So that report was done. I'm going to open it up to page. Well, it doesn't have page numbers, of course, but attachment 2 of that report, I'll give the board the entire report, but I'll just do this for attachment 2. You can see the location of the hydric soils. They're much further towards the water than what
Okay.
this plat shows. They're not nearly as close. And as you know, if you have hydric soils, you have to
14.
expand the buffer. So if the hydric soils went beyond the buffer, you would have to expand the critical area buffer. None of that took place here.
Okay.
Mr. Stevens, on, you submitted number 9.
Looks like this was one whole package.
Yeah,
It was an
was, yes.
entire.
Did you keep a page of it?
No.
No, we'll pass it all down.
Jim,
On your administrative
That's 14.
subdivision that you submitted, what was the purpose of this subdivision?
The purpose of that subdivision was to actually take, I believe, 5 lots and make it into 4.
Okay.
This was one of the lots under ownership, but it didn't change this at all. They didn't touch this, they didn't change the size, it stays the same size as it had been since 1947. It locates a sewer easement in front of it, but that's all that it does for that lot. And the reason I gave it to the board was to show that, the applicant, or the predecessor to the applicant, didn't come in and change the lot, make it a little bigger or something, and then come in for a variance after. This is the 1947 pre-zoning lot.
Applicant Exhibit 14 for the record.
I have one other thing for the board, because I do think that it's relevant. Can you expand out a little bit, please, Mr. Owens, on that aerial? Can you push it back a little, or is that the best you can?
The pictures are locked in where they're at right now.
Okay, all right. There's a lot kitty corner across the street. It's known as map 57, parcel 378, lot 58D. The lot itself, it butts on, just kitty corner to this, on Benton's Pleasure Road and Cedar Road. And the owners of that lot, Mr. and Mrs. Powell, in 2023, requested a variance from this board from Cedar Road to build a garage, I believe, and some other improvements on the property at 20 feet from Cedar Road. The board approved that variance, and I do think it's germane, because this is essentially the same request that was done then. So I just, for the record, given the board a copy of that decision.
okay.
Applicant Exhibit 15 for the record.
I was just going to ask the owners a couple questions and have them up here to answer any questions you have, and then my case is concluded.
I don't have any more. You got any more questions?
Sure, now.
Everybody's good.
Okay, thank you.
Got another witness.
Thank you. Yep, just the owners. And then, come on up, both of you, Sharon, and pull that around, thanks. Can you identify yourself for the record, please?
I'm Brian Lipford, And Sharon Lipford.
Okay, and how long have you owned the property?
More than that, year and a half.
Speak up so that,
So,
Speak up. Speak
year,
to the-
year and a half, I don't know exactly.
okay, all right, but it hasn't been a long period of time, right?
No.
Okay, all right, and what's the desire in terms of the design of the house and your needs for a house that's a bit wider than the long, narrow structure described by the architect?
So we considered with Mike, the options, and again, the long and narrow has the restrictions that Mike talked about, and I wouldn't say it's not doable, it makes the house, harder to work with and harder to be what we were hoping to achieve with the rooms
Okay.
and the spaces.
All right, so the alternatives to designing a long house are not practical in your view?
Yes,
Okay, and they create a difficulty in your view that's not shared by others in the area, is that correct?
that's correct.
Okay. Now, in regards to the improvements you show on the site, you know that you are pretty close to the 100-foot buffer and that you will not be able to get any variances to put anything in that 100-foot buffer. Is that correct? You've been advised that and you know that?
Yes.
Okay. So any other improvements you want on this property, whether it be gazebos or pool or anything like that, will need to be on the street side?
Yes.
Okay.
I
And you've
understand.
left enough room there for that, is that correct?
Yes.
Okay. I don't have any further questions for them.
When you talk about it, the longer house is not practical, can you elaborate on how you mean that aside from the cost? Because that's really not relevant, the fact that it would cost a little bit more to what we have to consider. So what, and this is similar to what I asked the other gentleman, what challenges would that more narrow house pose for you in terms of your use and livability of the house, if you can?
It's just, you have, instead of having a group of rooms kind of like central, you're going to have one room, a long hallway, another room, and a long hallway. So it's going to be a lot of motion to move between rooms. We're going to have her mom living with us, and she's going to most likely be in a wheelchair. So it's just going to be more difficult to move around in a long, narrow house, especially with her room on the first floor.
So we've designed the house plan to allow for her to be on the first floor with a full bathroom, with wider doorways to accommodate the wheelchair to go through. She's 83.
Thank you.
Any more?
I don't have any more witnesses now. Okay.
Anyone else in favor of this application like to speak? Come right on up.
Hi, my name is Gregory Lipfnock, and I live 3 lots down.
Have you got an email?
Yes,
or-
Greg L. at kmaf.cpa, and I live at 310 Benton's Pleasure Road. So I'm 3 lots down. I've seen this design, and visually, it's more appealing to me looking from the outside, living down to the south. And it, given what I've heard, it makes more sense to have a house built like this rather than having it elongated.
Anything else?
That's it.
Okay, thank you.
Thank you.
Next.
Dean Gray. Email address is dean.gray.md@gmail.com. I live at 316 Benton's Pleasure. So, my wife and I live 4 lots down from this proposed home, and we would be looking directly at it as we'd be on the same side. Our desire is we like the design wider because it's more aesthetically pleasing to us to look at. And at the same point in time, we feel it would improve the property values of the rest of the neighborhood and be, what we don't want is a long, narrow, industrial-looking building on a waterfront lot in our neighborhood. So we support the design as it is, and that's it.
Okay, thank you.
Yeah.
Anyone else in favor?
My name is Arshawn Human. Email address is axhooman@gmail.com. And I live 2 parcels down south from this one at 306 Benton's Pleasure. My wife and I just actually built on that property. You can kind of see the edge of the house. We are in favor of the variance being approved. Echoing what both Dean and Greg mentioned, we will have direct view of that house. So having a house that kind of looks a lot more like all the other homes in the area, not an industrial looking home, is a lot more aesthetically pleasing, especially when you're in the kitchen, in the dining room, eating. You're not looking at an Amazon warehouse or anything similar to that, right? So we are definitely in favor of the variance being approved.
Thank you. Anyone else? Anyone opposing the granting of this application? Come up. You're opposing it? Come up, speak.
Actually, Kathy had that. Emails for you.
So we appreciate the opportunity to speak to you tonight. My name is Carrie Gregory. We own 210 Cedar Road. My wife Janet and I, who are here this evening, 210 Cedar Road is lot PT10, one of the 3 impacted lots. It's great to hear from everybody tonight, but we're the ones that are most close and in proximity to the variance request. We have a lot of empathy. We too spent over 2 years looking for our forever home and have spent the last 4+ years restoring an 1800s property. So we have a lot of empathy, but we also have concerns. And I've just got a handout that might be the easiest thing.
I'm gonna label this Opposition Exhibit 1.
Thank you.
Stevens, you got a copy?
I do not. Do you have an extra copy?
Can we get copies of?
Yeah,
I've got whatever's up there. Thank you.
So first off, one of the things, we just went, and I'll try and go through this as quickly as I can so as to not waste anybody's time, but looking at Chapter 18 and effectively identifying the 5 key points of what is and isn't in. So the first is enforcement of 18.1 result in unnecessary hardship. Our perspective is no. We just heard from, I'm going to call him Architect Mike because I'm not going to butcher his last name, that there are other options. Are they ideal options? That's in the eye of the beholder. We recognize that. We too have had elderly parents live with us. We understand the challenges that go with that. But I think it leads to some of the more specific things. And I have to be candid, I'm very confused on the subdivision conversation because we were notified in 2023 from an attorney when the subdivision was happening that these lots were being restructured and basically that we had no say in it, but don't worry about it, there's a 35-foot setback. I called the attorney, had a conversation. So when we're saying that that lot was in existence since 1947, that doesn't seem to jive with our understanding when the subdivision was done and the 2 lots were turned into 3. I've heard different numbers, so I'm a little unclear on that. If you go to page 3, this is another point of clarification or confusion. When the lots were subdivided, this lot was not a Cedar Road lot. This was 378 Benton's Pleasure. and that's how it was put in the listing, and that's how it was basically put out there, with the 35-foot BLRs in place in both directions. Again, we didn't take any action when that subdivision was happening because we were told that the BLRs were in place and that was our protection. If you go to page 4, there's a sample of the listing. It was very evident that this was an impaired lot, that this was had a restriction when it was sold. The listing was very clear, so we're a little confused as to why buy a lot and build a house that, effectively trying to put an aircraft carrier on a postage stamp, understanding that, long and skinny is maybe not ideal, but Greg's house is exactly that long and skinny, and it's frankly, at least from the exterior, a beautiful home. His home is, as he referenced, a couple of lots down. So I'm not sure that the aesthetic aspect holds as much water. And again, it was obvious and clear to all parties that it was, in fact, had a limited building envelope. Page 5, just looking at, will the variance be contrary to the public interest? Our assessment is, of the 6 items in that categorization, public safety and access, really not an issue. The aesthetic appeal and community character, we feel strongly about that moving into Cedar Road is going to create more of a corridor effect, and one of the beauties of the area is the open space. And now it's really open as the shoreline's been cleared for all of those lots down to dirt. It's a very different look than it was even just a couple of weeks ago. Are utilities and infrastructure going to be impacted? No, not that we can see. Stormwater management and runoff, to me, that remains to be seen, because anytime you change the landscape, that's something that needs to be navigated. We spent a lot of time in our restoration. The culverts had all been filled in. We dug those all out, restoned them to try and navigate the water, because there was a lot of flooding in that area of Cedar Road. Landscaping is another one. I'm sure that they'll do a fine job, but it certainly has an impact. And then obviously zoning regulations. Are there floor plan options that will allow the enjoyment of that property? Yes. Are they ideal for the folks? And I want to stress too, none of this is personal. We don't know the folks, and it's not at all personal. It's just a matter of us looking out for our best interests and what happens to our property value. The only 3 opinions from our perspective, other than the Lipfords, are the 3 properties that are directly impacted by this. The other folks that spoke, that's great that they're supportive, and I appreciate that, but it really doesn't have an impact or bearing, because they're several homes away. That's, I think, about as quick as I can get through that, but it hits I think, some of the highlights. That is it.
Mr. Stevens, you like the question?
Quickly, you didn't evaluate any stormwater management plans or runoff plans for this
Didn't say I did.
Okay, but you said it would have a negative impact.
I said that it potentially, anytime
But
you
you have no
change.
basis for saying that.
I
except
have
for
every
the-
basis from the standpoint of being in the construction industry for 35 years, that anytime you change a landscape, no matter what you do, if you pour concrete, if you put a foundation in, there are implications with water management that have to be addressed.
So that would happen whether it's a elongated house or not.
It would happen, yes, it's an implication that needs to be addressed.
All right, thank you. That's all I have.
Thank you.
Thank you.
Anyone else opposing this application? Right up.
Hi, how are you? I'm Jeffrey Berman, and my contact information is on carry sheet, so do you have that correct? Yeah, a lot of what I have to say is reiterating what Mr. Gregory mentioned.
What's your address, if you don't mind?
208 Cedar Road, Chester, Maryland, 21619. Yeah. The key thing here is it was well advertised and well known going into this that the lot was the width that it was, full stop. I mean, it's just unarguable. It was bought, and then a larger house was designed. The house next door to the south was available at that time and accommodates a larger house. But that lot was chosen, and we did not contest the subdivision because of the setbacks, and feel that that should be upheld. It shouldn't be a stepping stone. Let's do the subdivision, now let's hit them to widen this, because when we come down, one of the important things for us is community continuity and open space. And there's many examples in the territory that's this in and everywhere that open space is important. And that's important to us. As we come down our driveway, we want as much open space as possible, and that's why we didn't contest it when the subdivision came out, because it showed 35 feet. You with me? With that being said, I think, and I just want to say, one of the witnesses that they value open space as well, because the covenant restrictions put on the house next to Mr. Gregg was that within the area there shall be no improvements, whether temporary and permanent, including limited landscaping, vegetation planting, grading, garage, greenhouse, shed, barn, bathhouse, maintenance shed, fence wall, awning deck, gazebo tent, swimming pool, tennis court, playhouse, blah, 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 blah. I think this one is not impacting him, but when it did impact him, he put all these covenants into that lot. As you know, the one 3 lots out owned all those lots. Are you familiar with that? No. Okay. Mr. Ludwig, I'll just call him Greg. He owned all that property.
With my sister.
Yeah. They subdivided that, okay? And they put certain covenants on the one that more impacted them, is my point. So there is an appreciation for open space to that point. So there's those things. And again, there's many examples within the Queen Anne County with the area that it's in and everything. One thing after another emphasizes open space, and we value open space, and we feel it affects our property value if we're more closed in. And that's all we want, is that respect. I truly believe the Lipfords would be happier if their driveway was off Benton's Pleasure Road as originally intended, because when there's snow and heavy rain in that area, that skinny little road, if you go off the edge, you get stuck. It's very soft, and there's going to be times where 2 people are going to be head to head with each other, and somebody's going to have to back up, and if you go off the edge.
I'm going to object. This has nothing to do with Cedar Road and where they take access. They can take access regardless of what size the house is.
Yeah, that's fine. They can take access, but I'm just saying, for their sake. But anyway, all right. And the White House that council talked about with the 20-foot setback is on the paved part of Cedar Road across Benton's Pleasure Road. That is not on this part. I just want to make that clear, okay? Because I think there's a difference there. That road is slightly wider, and it's paved and maintained by the county. Okay, so that's significant. I also, I don't know if you recall, but when we were here in August and we weren't able to continue with this continuance, and they were advocating, council here was advocating for a September 15th date. And he said because they want to start building regardless of the decision, which means they were very prepared to build a house on the existing envelope.
To do with that, because it was this office that designated the time that we hear the case.
Right, what's that? I'm sorry?
We specified October. That's the only time we could meet, so that they
No,
don't
I know.
have anything to do with that.
All I'm saying is the statement was made that they were ready to build whether they got it or not.
It wasn't during a hearing, and I don't even know if the statement was made.
Well, I do. I was sitting right there and heard it.
Well, the only reason it's now instead of then is because they were gracious enough to let us push it back for your convenience.
It wasn't for my convenience. Yeah. Okay. So I think those are the main points. Again, it was advertised the way it was. We didn't contest the subdivision the way it was. And I think that should be respected. I don't think we should have to suffer because somebody else bought something knowingly and wanted to change it, which impacts our openness and community feel.
Thank you.
Okay.
Stevens, you got any questions?
One question, could you just put a circle around your home on that, because it's not up on any of the boards, so that the board, I want to show the board which house is yours on that plot.
Yeah, and my house is here, but we drive down that road
Right.
every day, and it makes it feel more closed in.
Understood.
It's not about my view from my house. I just want to make that clear.
I don't have any other questions.
Where's his house?
Right there.
Oh, right here, I see it now. Here's a lot. He comes in this road.
Yeah, got it.
This would be opposition to.
Not shown on
It's an
that.
existing document, he was just pointing it out. I'll mark it on the existing document as well.
That's fine with me.
All right, anyone else opposing? Let the record show there are no one else.
We're going to swap this version in for opposition Exhibit 1 since it's been marked.
Okay, thank you. I do have a couple of,
We need.
Closing matters.
There's nobody else?
I do have a couple of things I want to clarify. I provided that big subdivision document to you so you could see that the Lipford's property hasn't changed since 1947. It was the other lots to the south that were recombined, and if you look at that document, Mr. Liffenach and his sister took more lots and made less out of them in order to create a better buildable situation. That was an administrative subdivision, it wasn't creation of lots, okay? The 35-foot setback, I'll testify to, and can provide to the board, has been in existence in the zoning ordinance since 1964. There's always been a 35-foot setback. We don't contest that. How it was advertised and what realtors put forth, again, is completely irrelevant, because if a lot meets the variance standard, then a lot meets the variance standard. If it's unique in terms of its, because of its physical characteristics, and the uniqueness results in a zoning regulation impact that is disproportionate to others, to most everybody else, you know, that they don't have the same impact, then it meets that standard for a variance. And you don't have to show that they can build something on the lot. That's not the standard at all. It's not a critical area buffer standard, where if they could put the gazebo someplace else outside the buffer, they don't get the variance. Or if they could put the pool outside the buffer, they don't get the variance. It is that, that disproportionate impact on them, and disproportionate impact means that they cannot reasonably do what others do in the same zone. And so having two road frontages is the complete impact on this property. It's been recognized across the street. And while those opposed have testified that it has an impact on them, open space, I'm not quite sure what that means, but those to the south also look past that property. You know, they can't be disregarded. So we asked the board to approve this variance. We think it would be approved almost 10 out of 10 times, and we asked the board to consider the evidence and testimony, and that it is an approvable variance that will withstand any court review. Thank you.
Well, I mean, we can have a discussion if you want. I don't know that we need legal advice, at least at this point. I don't believe the two road frontage issue is relevant on this one, because clearly Cedar Road is the front road to this building based on the address and the orientation of the house. So I think that that's noise. I am having a bit of a hard time understanding how, as much of the opposition was about protection of open space, and this variance would result in a smaller footprint and a smaller build than if they have to go with the more narrow footprint that would actually be a bigger building and take up more space and more view. So I'm not finding that particular aspect of the arguments particularly compelling. Now we're closed.
The runoff wouldn't have anything to do with it, period. That wouldn't affect it at all.
I'm talking about visually, yeah.
I mean,
I do think it is noteworthy that it was clearly advertised what the setback was and that they proceeded with purchasing it anyway. But I also personally do find it tough to believe that you could put a usable, handicapped, accessible master bedroom on the first floor in that narrow footprint.
Well, it's for her mother, so.
Right, that's what I mean. I'm having a hard time believing, based on the testimony, that it would be a viable, handicap accessible bedroom if they had to stick to the narrow footprint.
Oh, with the narrow.
Yeah.
Yeah. I'm not against this at all.
So, well, those are my various thoughts on it.
Okay.
Do you guys have thoughts?
I think we're ready. I'm ready.
Can we have the criteria, Tim?
Yes, you may. Do you find that literal enforcement of Chapter 18.1 of the Code of Public Laws of Queen Anne's County would result in unnecessary hardship or practical difficulty as a result of the specified conditions?
Yes.
Do you find that those conditions are peculiar to the property?
Yes.
Do you find those conditions are not the result of any action taken by the applicant?
Yes.
Yes.
Do you find that the variance will not be contrary to the public interest?
Yes.
Yes.
Do you find that an evaluation of alternatives proves that a variance is required?
Yes.
And in making those determinations, have you considered the ability of the applicant to use the property for any reasonable purpose, whether or not they desire such purpose in the absence of the variance?
Yes.
Have you considered the degree to which the proposed variance will affect adjacent properties?
Yes.
Yes.
Have you considered the impact of the proposed variance upon the resource protection provisions of Part 4, Article 9 of Chapter 18.1?
Yes.
Yes.
And have you considered the degree to which the situation might be more properly addressed by amending Chapter 18.1?
No, that's outside our purview.
Okay. That's it.
Is it? You have a motion? Is this 14? Would be, wouldn't it? Because of the critical area in the back? Or the 18? It's 18.
I think it's 18. In regard to case BOA 25060221, I'd like to propose a variance to reduce the required 35-foot front yard setback from Cedar Road to 20 feet in order to construct a two-story single-family dwelling, including garage, covered porch, and deck.
I'll second that.
All in favor?
Aye.
Thank you, board members.
I now declare this hearing to be adjourned and receive a formal decision as soon as possible.
Ask a question on that, sir. The appeal process, does that start once we get the notification, or is that something?
Can't hear you.
I'm sorry, I apologize. Does the appeal process start once we get that formal notification, or is that something that starts now? The clock on that?
Or is it, they get, the decision is written.
Understood. Thank you.
Do you have enough comments for everything, or did you?
I do.
I thought you were getting them all response. Two.
Do that.
Oh, thank you. Warming up for me. So it's
Well, I understand what you're saying about the rooms
That's my reason for
Yeah.
granting this.
for letting them have.
Yeah. So,
And I don't see anything about the lot.
when the one guy, the house is gonna be closer to where he turns off the road if they have to build it longer and narrower. It's gonna
Yeah.
be farther from his turnoff and his visual impact.
I don't understand sometimes.
And he said at the end, it's the visual impact.
Yeah.
Basically just driving down the lane. It's not
You get behind farm machinery?
I can find a lot of fun.
A lot?
Yeah, it's all of 213.
You were
Come
coming
on.
from Easton?
I was, and
Yeah.
I had my ways set to be here at about quarter of.
that's always my answer. It's outside of our purview. I don't know why they ask us that one.
I just did it because it's in the code.
No, she always asks it.
Okay.
Better to ask it and have us say no
Yeah.
than skip it and somebody say you missed a step.
Let's look at this one.
It amazes me that they're thinking about appealing this. No, yeah, tired, yeah.
That's a long. Oh, yeah.
That's the war of attrition.
Yeah. You get Liz, they can get a Liz Pendens on the
Yeah.
property.
They'd have to go to circuit court to appeal that.
I don't have nearly as many exhibits as
I do want to say again, thank you for letting us do that now so they could be heard rather than.
I wouldn't hold something up like that. And, you know, I don't recall saying I didn't care what the board decided we needed to build it. That I didn't, doesn't sound like me.
I don't think we were ever on the record last time regardless.
No, except for when you continued it. That was the only time you went on the record.
If you need them.
The thing
Thank
we
you.
did was decide for the date.
Yeah.
Refer to this a couple times.
Okay.
That's the 1978 aerial. if you
Oh,
need to
excellent.
kinda-
Okay, thanks.
That's like the first time. This was
They were-
1977.
And then they built the deck after that.
We still on
Yeah, but before critical areas.
Can't be.
Yeah. Okay. I'll see if I need it.
They've got all theirs marked and I've got.
I think he does. He cuts it off.
Those are just the surplus.
He did last time.
Is he ready back there? Okay. Wait a minute.
Pay no attention to the man behind the
I
curtain.
now declare this hearing to be in session. We are here to hear case BOA 250702223, Paul and Elizabeth Sachs. All that wish to testify, please stand and take the following oath. Do you solemnly swear or affirm under the penalties of perjury that the testimony you are about to give will be the whole truth and nothing but the truth?
Yes, I do.
Let me see now. Ms. Maxwell, has all posting notifications requirements been satisfied? And any matters related to jurisdictions of this board will now be heard. Let the record say there were none. Department of Planning and Zoning will now be heard.
Good evening, Mr. Chair and members of the board. I'm Mary Ellen Gray, Senior Planner at the Queen Anne's County Planning and Zoning. I'll be presenting this case. I also present this evening are the applicants, Paul and Elizabeth Sachs, as well as their legal representative, Joe Stevens, and engineer Brandon Davis. The applicants are seeking a variance from sections 14.1-51A buffer standards and 14.1-52B, expanding the buffer in order to replace an existing deck with a screened porch and remove 2 existing sets of stairs and replace with 1 set within the expanded buffer. This property is designated Limited Development Area, or LDA, in the critical area. The property is zoned Neighborhood Conservation 2. This property is located south of Queenstown and east of Graysonville, just west of Sportsman Neck Road. It is located in the Hickory Ridge subdivision. Looking at the aerial view of this property, it is located on Edge Knoll Lane. The size of the property is just over 3 acres at 3.09 acres. The property is part of the Hickory Ridge subdivision, as I just mentioned. The lot is improved with a single-family dwelling that was built in 1977, detached garage, driveway with loop, a pool, a patio, a pier, deck, 2 porches, and 2 carports. The deck was added by the previous owner in 2004, while the 2 carports, detached garage, 2 porches on the front, and pool were more recently added by the current owner. The property, as I just previously mentioned, is zoned Neighborhood Conservation 2. Single-family dwelling is a permitted use in the NC2 district. As I just mentioned, this property is designated limited development area in the critical area. The property has numerous environmental features. These include steep slopes on the waterfront and southern portion of the property, non-tidal wetlands on the southern portion, tidal wetlands along the southern waterfront portion, highly erodible soils along the waterfront and southern portion, and hydric soils adjacent to the mean high water line. Let me take a minute to explain briefly the difference between highly erodible soils and hydric soils. Essentially, highly erodible soils are susceptible to rapid soil loss from wind and water due to properties such as soil texture and slope, while hydric soils are characterized by prolonged periods of saturation and support water-loving plants such as those found in wetlands. The two environmental features that impact the critical area buffer on the subject property are the highly erodible soils and steep slopes. For according to Queen Anne's County Code 14.1-52A, highly erodible soils and steep slopes constitute sensitive areas whereby the buffer shall be expanded to include these sensitive areas. Further, COMAR 27.010901E7C indicates that the buffer shall be expanded to the lesser of 300 feet, including the required buffer or the landward boundary of the highly erodible soils. In this case, the expanded buffer is the landward boundary of the erodible soils, as indicated in the pink dotted line. The applicant is proposing to replace the existing deck in kind with a screened porch within the expanded buffer, indicated in the gray-blue rectangle on the water side of the single-family dwelling. The footprint of the deck is 616 square feet. Two sets of waterfront steps totaling 66 square feet will be removed. This will increase the setback from mean high water by 5 feet. A new single set of steps is proposed facing the existing patio and away from the waterfront, totaling 16 square feet. The proposed screened porch will be built on columns similar to the existing porch, which will minimize soil disturbance. A small area consisting of 88 square feet of existing brush and shrubs adjacent to the existing deck will be removed to provide access for the construction of the proposed screened porch. The granting of a variance within the expanded buffer requires a buffer management plan at a rate of 3:1 for all new disturbance and for all mitigation to be planted within the expanded buffer, as well as a rate of 1:1 for replacement or removal of existing brush and shrubs adjacent to the existing deck to allow for access. The applicant has submitted a buffer management plan. The highlights of this plan include the total area of disturbance, which is 582 square feet, at a rate of 3:1 ratio. A total of 1,746 square feet of mitigation is required. There is a 50 square foot net decrease in lot coverage due to the removal of the two sets of steps and proposal of one. The total area of existing brush and shrubs adjacent to the existing deck to be removed and replaced at a ratio of 1:1 is a total of 88 square feet. The applicant has submitted a planting plan for a total mitigation of 1,834 square feet. And that consists of one 1-inch caliper canopy tree, 8 large shrubs, one planting cluster consisting of 1 canopy tree and 3 large shrubs, 3 planting clusters consisting of 2 understory trees and 3 large shrubs. The applicant has also submitted a narrative dated September 18, 2025, addressing all the required findings. Moving on to considerations for required findings of 14-1-66 and Comar 2701-1204. Regarding the consideration of unwarranted, unnecessary hardship based on the land and the particular property, which hardship is not shared by owners of other property in the same development area, as well as considering the entire parcel. There are several factors to contemplate. First is according to Comar 2701-1201, unnecessary hardship is defined as without a variance, an applicant shall be denied reasonable and significant use of the entire parcel or lot for which a variance is requested. The existing deck is attached to the single-family residence that was built in 1977 prior to the adoption of the critical area regulations. Most of the development on this parcel is placed near the existing single-family residence. The expanded buffer encompasses a portion of the single-family residence, the entire existing deck, and most of the land area on the waterfront and southern side and the area around the single-family residence. The septic tank's location prevents a porch larger than the existing deck that is currently there on the southern front portion of the single-family residence. On the other side, the pool patio located on the northern side of the property precludes any further building on that side. That leaves the front northern portion of the single-family residence, which is located outside the buffer, as a potential spot for a screen porch. This area includes a small deck that has recently been built. It should be noted that this location is not waterside. There are a number of properties in the same development that have waterside decks, porches, and patios. Regarding whether literal interpretation of the critical area program deprived the applicant from a use or structure permitted to others, the several factors to contemplate include: a single-family dwelling is an allowed principal use of NC2 zone property, and while the board should make the determination whether the proposed screen porch is a reasonable use of the property, a screen porch is a normal improvement of residential property. Regarding the standard that the requested variance must be the minimum deviation necessary, the factors to contemplate include: the screen porch will be built on columns similar to the existing deck, which will minimize soil disturbance. The applicant is proposing the screen porch to be an in-kind replacement of the existing deck. The stairs to the screen porch will be reduced and increasing the setback to the mean high water by 5 feet. Regarding the purpose and intent of the critical area program, the factors to contemplate include: Chapter 14.1 allows for applicants to request a variance, but in general it is not considered to be consistent with the purpose and intent of Chapter 14.1. The protection for land, habitat, and water resources located within the Chesapeake Bay critical area. Though it is required by Chapter 14.1, in order to grant a variance, an unwarranted hardship must be found, of which considerations were just discussed. The awarding this variance will not result in a use that is not permitted. The proposed project will reduce lot coverage overall, and that within the expanded buffer, and increase the setback to the waterfront by 5 feet. Finally, regarding the effects on water quality, fish, wildlife, and plant habitat, the factors to contemplate include: as discussed in this presentation, the applicant is required to submit a buffer management plan. A minor buffer management plan has been submitted for the 1,834 square feet of disturbance. In conclusion, staff recommendations is that staff does not object to the Board of Appeals granting this variance, but the board should further identify the unwarranted hardship, specifically due to the fact that all locations adjacent to the dwelling should be analyzed and evaluated. For this, I offer that the board contemplate the considerations for unwarranted hardship presented on the previous slide. If the board clearly identifies unwarranted hardship and is inclined to grant the variance proposal of 14.1-51A and 14.1-52A to construct a 616 square foot screened-in porch within the expanded buffer, staff recommends the following condition. that the applicant cannot receive a building permit for the proposed improvements until the buffer management plan in accordance with Comar 270109-01-3 has been approved by Queen Anne's County.
Is that a condition, though, or is that just a hard rule?
That's a recommended condition, but it certainly would be something staff would do anyway.
Because if it's a rule anyway, then we normally don't make those conditions. So that's why I
Fair enough.
wanted to confirm and clarify.
Fair enough. That concludes my presentation.
Mr. Davis, we want to enter the applicant exhibit 1
Yes,
through
please.
9.
Yes, no objection,
Okay.
please. Thank you.
And,
That includes the narrative,
pardon
including the narrative that Mr. Davis provided.
me, and his name is Mary Ellen Gray. Thank you, go ahead.
Okay. Thank you. Joseph Stevens on behalf of the applicants, the Sachs. And I'll just start by saying that when I talk to clients or potential clients about buffer variances, I always caveat it by saying they're difficult variances to get. They're looked at very hard by the staff and by the critical area, and there's some pretty high bars that you have to achieve. I think a point in fact is you'll see in the evidence that the Sachs just built a pool on this site, and they located the pool on the side of the house outside of the buffer, make sure that they didn't need a variance for that. But when I looked at this with them, and I looked at the unwarranted hardship standard and whether or not they could do this someplace else based on a reasonable evaluation, it became clear that it could very well fit into the variance standard for buffers. Point of fact, critical areas filed no objection to this, and you know that if there was a problem, they would have filed an objection. The Sachs this house has been built since 1977, and the deck has been there since pre-critical areas. I think that there was some comment that the deck was built in 2004. It was rebuilt in 2004. A permit was issued for it, and I'll put that in the record and all that, and Mr. Davis will testify to it. But the deck had been there pre-critical areas as well. And what we're requesting is to build a slightly smaller deck on the same footprint and to screen it in, a screened-in porch. It's not going to be a three-season room. It's not going to be air-conditioned or anything. And the options that they would have, if they wanted a sizable screened-in porch where you could do things like have a family outside gathering, outside of the bugs and all that, in the rain, their only options would be the front of the house, and their septic there, and it just is not a reasonable location for that. Plus, you'd still have the lot coverage for the deck, because it exists. And then you'd be creating more lot coverage, maybe at 130 feet versus, within that slightly, the encroachment of the buffer. So with that, I'm going to ask Mr. Davis if he'll come up, and I'm going to have him walk through what he did on the site and identify himself first for the record.
Good evening. I'm Brandon Davis. I'm with Davis Moore Sharon and Associates. We're representing the civil engineering and site planning aspects for the project. We've been assisting the Sachses since they purchased the property on various aspects of their improvements, and we've been working with staff on this particular application to lead to us sitting here tonight.
Okay, and you have experience in planning and design. You're an engineer in terms of designing improvements within the critical area?
Yeah, a large part of our practice is working with clients who own properties in the critical area. I've been practicing for 11 years with my professional certification, assisting with site design, stormwater management, utilities designs, but then specifically in this, applicable to this scenario, critical area code compliance, site zoning, et cetera.
Could you describe the property? Physical characteristics, please.
Physical characteristics of the property. We're at 101 Edgenole Lane, as the property is 3.09 acres. It is labeled Lot 10C in the subdivision, and the lot area includes a 50-foot wide right-of-way that is the panhandle feature that you're looking at on your screen behind you.
Was the lot created in 1972 based on this subdivision plat that I'm showing you?
Yes.
Okay, I'm going to give that to the board and ask you to mark the next exhibit in line.
Lot 10 of, I believe, Phase A of the overall subdivision was then further subdivided into what you have in front of you. So Lot 10 turned into Lots 10A, B, and C, and that right-of-way that I just noted.
All of the Hickory Ridge subdivision?
Lot 10 is also going to be applicant Exhibit 10.
Perfect. Okay, thank you, go ahead.
To be 10.
Yes.
So, describing the existing improvements on the property. The existing dwelling footprint, we have survey data. Without porches, that dwelling is 2,073 square foot. The tax records, again, provide that in 1977 it was constructed, and that's corroborated by a aerial image that is public on the county website from a 1978 date.
Is this a copy of the aerial image?
Yes.
Okay.
It appears to be a freshly constructed.
That's from 1978.
Yes. A driveway accesses the right-of-way to the existing dwelling, and then a driveway loop has essentially always existed from the original lot layout, as you see on that Exhibit 11 that's in front of you. Currently, there is a pool and detached garage on, it's actually the northern property line, but it is the right side if you're standing at the house looking at the water. There is the rear impervious deck, which is the subject matter that we're here tonight. We have two front porches that have been noted, I believe, and I would be hesitant. I mean, they are covered. They are. They do have a a footprint area, but they appear more of as a narrow front stoop, in my opinion. They're not exactly practical to sit with a group of people. Again, the septic is
And they wouldn't
located.
take advantage of the view, right? The view would be
Right, and
blocked.
they're staring at a driveway loop is their view from the front.
Very entertaining.
Sorry?
I said that'd be quite entertaining.
We have the septic in the front yard that has been recently replaced with current health department standards. I don't know if you can see it on that image. There's a
Want to
white.
point it out?
Sure.
Use the
You can
pointer?
see the 3 drain tile trenches that lead back towards the house, and the septic
Wait.
tank is
Yeah,
right in the front.
I'm trying to get the pointer. Wait, arrow options, automatic. Am I getting a pointer? No, my pointer isn't working. Oh, pen, here we go, laser pointer. Okay, I got it now. Okay.
All right, there you go.
What I'm pointing at?
So the septic, you're almost on top of the
Yeah,
septic
there
trench
we
right
go.
there,
Yeah, right
which
there.
is
Yep.
quite close to the existing facade of the main portion of the house, and also right off the corner of one of the front covered stoops, I'll be specific.
See these covered stoops. And Mr. Davis, would the septic be essentially where the bush is?
Roughly, yes.
Where the bush is on the left-hand side? Thank you.
Number 12.
And then you'll also note a very large tree that is on the right-hand side of that Exhibit 12 image that Mr. Stevens just provided you, that the owners have taken extra efforts with the tree service to prune and make sure that that tree stays healthy.
For the record, this is applicant Exhibit 12.
So these two locations in the front essentially make up the only locations. One side is the septic, the other side is a very mature tree that the applicant's trying to preserve as long as possible. Is that right?
Right.
Okay, thank you. Go ahead.
So as we kind of delve into the environmental considerations, the exhibit that you have in front of you, the left-hand facade, which is really the southern side facade, is within the buffer, and that's a portion that isn't even a part of the expanded area. That's straight 100-foot buffer based off of the tidal wetlands that protrude into the site. The expansion areas are the crosshatch areas, which are on the image behind you are darker in color just because the crosshatching is such a tight pattern. There's an area there, and then as you get towards the pool on the other side of the existing deck, there's a small, within the pink line, yes, right there. So those are the two main areas that are expanded by the highly erodible soils. And as was pointed out, the highly erodible soils are based on the erodibility and the shear factor of the soils that are inherent to the subject property. And by definition, anywhere that the soil factor is greater than 0.35, and if the slope is 5% or greater, which is only a 1-foot rise over 20, so in my opinion, flat, quite flat, wherever those two scenarios exist is considered a highly erodible soil. Well, the soils inherent to this property, there are, I believe, 3 different types, but all of them have a 0.35 or greater factor. So essentially, wherever there is a 5% slope or greater on this property is a highly erodible soil. So then I'm looking at where that area overlaps the regular 100-foot buffer, and anywhere where that highly erodible soil is beyond it is where I have expanded.
And it creates quite a peculiar situation for this property,
Yes.
particularly given that the house was built in the 1970s, before all these regulations came into play, correct?
Yes.
Okay. I'm going to show you real briefly, because I want to get this in the record. So this is an old survey from dated 1984, and it shows the deck existing in 1984. Is that correct? Correct. Okay. And this was in the land records, and so we're just giving it to you. We don't know that the measurements are accurate or anything. You can see that they don't really go from the shoreline, so it's not, critical areas wasn't in effect, so I don't think the measurements are accurate, but what I'm trying to show you is that there was the deck there in 1984.
Okay, number 13.
So all this property's gonna be in grass, and
My next statistic for you was the existing lot coverage is right around 19,212 square feet, which is compliant with the 15% maximum allowed. So 19,212 is 14.3. So if you look at the areas outside of the existing lot coverage, we have a wooded area along the southern property line. The wooded area consists of approximately 20 to 21% of the overall property, and then everywhere else is scattered trees and grass. Yep.
So you went through the environmental features. Which one's that? Okay, go ahead.
Yep. So the owners have strived to respect the buffer throughout their desired improvements for the property. They've worked to mimic the exact shape of the buffer. So I first assisted the owners with the environmental
I mean,
mapping.
the deck, oh, go ahead, I'm sorry.
I'm sorry. I was just talking about like the pool and the patio. It's difficult to see on that image, but we've actually truncated the patio area. Instead of it coming to a 90-degree bend, it has like a 45-degree truncation. We're actually mimicking the shape of the buffer there. For the patio, we're keeping the detached garage on the the roadward side of the lot, and just the pool itself is in a side yard, which isn't exactly typical. You look at our two neighbors to the north and to the east, they have pools in their rear yard, which is typical. The applicants have cited this pool in the side yard, which was over an area that used to be impervious area when they purchased the property. So they've been quite respectful for their various smaller improvements, but they've been able to be creative and avoid the buffer and be respectful to the buffer until, we're here tonight. We're working with the existing impervious deck, and its entire footprint is located within the buffer. So the buffer disturbance is
Does this
unavoidable.
represent a picture of the existing deck?
Yes.
Okay, thank you. I just want to give the board a visual of what the existing deck looks like.
Number 14.
So the first image on that exhibit that has been presented to you shows the deck, but it more importantly shows the two sets of steps that protrude, I'll call it waterward, off of the deck. Both of those sets of steps are to be removed, and then the new flight of steps will be off the left-hand side of that first image. There's a railing that you can see on the very left that's kind of embedded into a bush, and that's where the new narrow set of steps will go. So we're by removing the two existing steps, keeping the same footprint of the overall deck itself, and then adding a smaller flight of steps to call it the left-hand side based on that image. We're reducing the lot coverage, and then we are increasing the setback of the improvements as they exist to the tidal wetlands and to the waterfront. So the existing flight of steps that is on the right-hand side of that first image, almost exactly 100 feet from the mean high water line, but the tidal wetlands come well onto the lot. So the existing setback of those existing steps, I believe, is 65.6 feet. Yes, 65.6 feet. So just the default result of removing those steps increases the setback to the environmental features resulting from this project.
So did you describe what the applicant is seeking to do?
Kind of started segueing into that with that last round of statements. So the applicant is removing those two existing flights of steps and then replacing the deck and replacing it's a 616 square foot footprint, replacing it in that same dimension and same area, using a similar decking board surfacing, using a similar piling or column-based construction, and then putting a roof on it to make it a screened-in porch
So it's
rather
not,
than an
it's not a
impervious.
slab it's not a slab on grade that they're doing, creating total impervious cover?
Right.
Okay.
Yep, there's no foundation walls proposed, there's no backfilled slab, so the soil disturbance will really be to replace columns, and it's not really an entire 616 square foot of torn up earth, so to speak.
And what are they putting on it? I'm just gonna move you along on some stuff.
I appreciate it.
Okay.
They're replacing it with a screened-in porch. As you mentioned, it's not a conditioned space. It's open to the elements aside from the screen, keeping bugs out.
Okay, and can you, and you went through the setbacks for all that, so can you describe, will there be any environmental impacts in your view as a result of putting these, essentially the screened-in porch over a newly reconstructed deck?
I don't feel that there will be any environmental adverse impacts given the nature of the in-kind replacement, the decrease in lot coverage, and the increase in setback. And furthermore, we're providing the mitigation that was presented earlier at a 3-to-1 ratio, so the plantings that are provided are a further benefit.
And if if the applicant had to put the screened-in porch someplace else in the front of the property, say, and remove that tree hypothetically, or get close to it, would that have potential adverse impacts?
I think it would be a great impact to a tree of that size. Our code and our mindset with environmental and sensitive habitat, we try to save large and mature trees like that, which the applicant has strived to do anyways. And we look at the areas that we have to work with out front, a new, impervious area of what we're proposing would increase impervious area too.
Right, so it's not an either or. I mean, if the applicant had to build outside of the critical area, this deck would continue to stay there, that is
Correct.
considered impervious and lot coverage.
Correct.
Okay, all right, that's what I wanted to get at. Okay, and did you have a chance to evaluate from a standpoint of the applicant not being, that the applicant meets the standard, that it's not requesting something that is denied to others with the same circumstances? Were you able to assess that?
Yeah, we reviewed just the general neighborhood. I prepared an exhibit and some statistics that include.
This is the exhibit you prepared, one with a plat of the subdivision and lots near the applicants, correct?
Yes, all.
And the other is a spreadsheet showing the square footage of building, including decks and so on for each of those properties. Is that correct?
Yes.
All right, and if you could, just for the board, again, I'm moving you along.
Yep. No.
But just for the board, if you could indicate what your conclusion was.
So after the evaluation, I concluded that
15.
not only does the reported above-grade living space for our site fall below the average, there's 11 total properties on that table, including our subject property. The above-grade living space is listed at 2,092 square feet. The average is over 700 square feet above that. So we're below living space average for, we'll call it the immediate neighborhood. I've looked at the average stories of the houses. We fall below the average stories at a 1.5-story dwelling. And then even I've done an evaluation. It's difficult to tell what's house, what's porch, when I look at aerial imagery. So I've combined the houses and any attached elements such as porches and decks and created a total area of that. And then again created the average of 3,454. And, where our proposed conditions are below that by approximately 500 square foot as well. So, we're smaller than the average grouping of improvements, so to speak. And I was just, the right-hand tables
This is, and the requested variance isn't the result of anything the applicant's done, right? They didn't take any action, done anything illegal or without permits and now asking for forgiveness. This is just the circumstances that the houses were in, that this house and the deck was in when the critical area law came into effect. Is that correct?
Yes.
Okay. Based on your evaluation of what others are generally permitted to do, and that where the only locations where the applicant could possibly put a screened-in porch outside the buffer in the front, is it your assessment that there is an unreasonable hardship on the applicant if not allowed to put the porch, the screen porch on top of the existing deck?
I would agree with that.
Okay, all right. And again, that goes back to your testimony about, well, we're making the deck smaller for one, it's there, it's not gonna have any environmental impact. I mean, it's kind of this overall reasonableness assessment you've made.
Yep. I would certainly strive to create an in-kind replacement and then the further reduction of impervious and increased setback.
I don't have anything further from Mr. Davis. I was gonna call, I'm sorry, go ahead, Commissioner.
Got no questions.
No question.
I'm just gonna call Mr. and Mrs. Sachs if they come up, because I just want them to, yeah, sure, you can leave it there. Why don't you guys sit there and identify yourself for the board, please, and,
Sachs?
Paul Sachs?
all right, and Kathy, you have all the emails, right? Okay, thank you very much. Could you just describe for the board how long you've had the property, when you moved down here full-time, and what your overall goal for the property has been?
We live here full-time. We bought the property in March of 2021 when our grandchild was born in Gaithersburg. And we realized that we lived too far away and it was time to retire and be with the grandkids. So we've been living there now full-time. We trying to make it into a magnet for grandkids. We have two, fortunately, now in Gaithersburg and one in the Philadelphia area, and we found a place in between. We fell in love with this property. It was an older house, and it was a smaller house, but the property, looking out over the river to the west, sunset, we just fell in love with it. And as we've been living there full time, we've tried to make some improvements to this older property. We're trying to stay within all the, permits and restrictions. As mentioned, just to clarify, we added this pool, which we couldn't put in the backyard, so we put it in the side yard. And then we wanted some hardscape around it, but we had to make the hardscape a very unusual shape to stay within the outside of the buffer. When we first bought the property, there was a beautiful patio, which is not shown here, which was within 50 feet of the water. And as we started going through the permit process, we were told that had to be taken away. So we took it away, and now it's grass. We had a septic system that was working fine. It was suggested, maybe strongly suggested, that we get a bat system, which we did. That had to be put in the front of the house because we also needed a new HVAC system, so we put in a geothermal HVAC system to be environmentally friendly. We love the trees. We use Bartlett Tree Service, and we did all this, root pruning to try to save the trees with the surrounding construction. Do you want to add to that? Yeah. Yeah.
We're really here because we moved from Connecticut to be near grandchildren, and they're coming because we're in the middle, and we love it, and we just would really like to have a screened-in porch because of the bugs, and it's safer, and all the things. That's what we're hoping.
And from the function of your house standpoint, it would be completely impractical to locate a screened-in porch off of the front, forgetting that that you potentially would damage that very mature tree, and you have to deal with the septic that you just put in. It just doesn't make a sense from the function of the house standpoint. All right. And you understand, because I have this conversation with all my clients that are doing variances, particularly where there are buffers involved, that, you won't be able to locate anything further in that buffer, and you've in fact taken things out of the buffer.
No, we're done.
We're retired
I would have
also.
told
We're
them
done.
not to take it
Done.
out until they came here and then offered to take it out, but that was
No,
after
we're
my
done.
time. I don't have any further questions for my clients.
You touched on my question. If you're sitting out on that current porch, pretty significant bug issue?
Yes, it's wetland.
Impacts your enjoyment of the,
And
of
our
the view.
kids, they're the ones too. And the grandkids.
Yeah.
Sure.
All about, talking about the bugs.
I know there's a couple neighbors here that would like to give you a brief support comment, and so I will excuse the
Thank you for your
Sacks and
time.
then ask.
Anyone else in favor of granting this application? Anyone? Come on up.
Larry Gotts, G-O-T-T-S, lawrence.gotts@gmail.com. Well,
your
thank you for
address.
giving me the opportunity to speak.
Get your address for the record.
I'm sorry, address 97 Edge Knoll Lane, Queenstown, Maryland, 21658.
I didn't tell the board.
Okay, so I'm in the home directly north, so I think I would be the one who would be most impacted if there were any impact or concern. And I have none and certainly supported. I would be kind of wasting your time to repeat a lot of stuff, but everything that was said, I fully, ascribe to. First of all, it's, if anything, this is improving the situation, right? It's smaller. The aesthetics will be, if anything else, but better. The aesthetics of putting it in the front, not to mention the environmental impact on the trees and everything else, would be not a substitute, and frankly, not an improvement in any respect as far as I can see. So I, and I know they're very respectful, and the Saxes are, have every intent to comply with any mitigation, which of course is, we all care about the waterfront, and I know they deeply care about the waterfront. So I am very supportive of that. As to the bugs, I can attest to that, being the property adjacent, and yes, I think they're, having some screened-in space, frankly, is, essential to the enjoyment of the property at certainly certain times of the year, not to mention, and the bees, as somebody who walks around with an EpiPen, same thing. So anyway, I'm happy to answer any questions, but I truly support it, and I believe it's an improvement and certainly no negative impact that I can see, given that it's smaller and the steps are going in the opposite direction and so forth, yeah.
Okay, thank you.
Thank you.
Thank you.
Anyone else in favor? Come on up. Your name and address, please.
James Smith, from Lundberg Builders. Our office is at 314 Main Street, Stevensville. Yep. I know mostly everybody at the planning and zoning office over there. One of the things I think I want to bring up is, these are going on columns. If we talked about that, it's not going to be a full foundation. We will be hand digging those and hand pouring those. We're not going to have concrete trucks running around back there. We're not going to have any equipment back there. We will be doing that all by hand. That's been our plan. We've been around for 47 years. We're well aware of this area of waterfront properties. And I think the fact, too, that hasn't been mentioned, is going to be a roof on it. So we have the opportunity to redirect that runoff. Whereas before, it's just running off the deck and it's going wherever. We will have the opportunity to get some gutters on that and pipe that out somewhere else. So I think at the end of the day, it's going to be a lot better system than what we got right now. All right?
Thank you.
All right,
Right.
thanks. Anyone else? Come right up.
Nice to see you all. We were here 3 years ago for our paper.
Oh, that's right. I'm so sorry.
A lot of familiar faces. Hi, I'm Judith Argon. My email is judith.argon@gmail.com, and we're at 110 Edge Knoll Lane. And so we are 2 houses up from where the Saxes live. And I completely, first of all, we have a screened-in porch. We look to the water. It's a wonderful gathering place for our family. We couldn't do without it. And even though there is mosquito control to some extent in Hickory Ridge, it's not sufficient, and this is a really important advancement to be able to sit out there and eat your dinners and with the family, or have the kids go out there to play. So we completely endorse it. We don't think that there are any negatives other than the small encroachment on the critical buffer. Thank you.
Okay, thank you.
Thank you.
Anyone else? Anyone opposing this application now be heard? Let the record show there were no one. Well, it looks like
Ready for the criteria?
the footprint of the deck, 616 square feet, it looks like it needs to be done. I mean, it's improvement. You're doing away with one set of steps and putting one set in.
You're bringing it back farther from the water.
Yeah, bring it back.
The point about controlling the runoff is compelling. It's going to be an improvement
Yeah.
in that regard.
So
I don't have any issues to discuss.
we're ready for the criteria, Tim.
Do you find that a literal enforcement of this chapter 14.1 would result in unnecessary hardship as the result of specified conditions, and that hardship's not shared by owners of other property in the same development area?
Yes.
Yes.
Do you find those conditions are peculiar to the property involved?
Yes.
Yes.
Do you find those conditions are not the result of any action taken by the applicants?
Yes.
Do you find the variance will not be contrary to the public interest or the policies, goals, and objectives of this chapter 14.1 in the Queen Anne's County Critical Area Program?
Yes.
Do you find that the variance will not confer upon the applicants any special privilege denied to other owners of like property and/or structures within the critical area?
Yes.
Do you find that the variance will not adversely affect water quality or adversely impact fish, wildlife, or plant habitats within the critical area?
Yes.
Do you find the variance is the minimum deviation from the provisions of chapter 14.1 that will make possible the reasonable use of land or structures?
Yes.
And do you find that the granting of the variance will be in harmony with the general purpose and intent of this chapter 14.1 in the Queen Anne's County Critical Area Program?
Yes.
And do you find that the variance shall not result in a use not permitted in the applicable development area or an increase in the applicable density limitations?
Yes.
And then under Comar section 27.01.12.04 variance standards, in accordance, do you believe the applicant has overcome the presumption that the specific development activity for which the variance is required does not conform with the general intent of the local program?
Yes.
And that the applicant has satisfied each of the following variance provisions? I'll go through them. The first, due to special features of the site or special conditions or circumstances peculiar to the applicant's land or structure, a literal enforcement of the local critical area program would result in an unwarranted hardship to the applicant.
Yes.
A literal interpretation of the local critical area program would deprive the applicant of a use of land or a structure permitted to others in accordance with the provisions of the local critical area program.
Yes.
That the granting of the variance would not confer upon the applicants any special privilege that would be denied by the local critical area program to other lands or structures in accordance with the provisions of the local program.
Yes.
That the variance request is not based upon conditions or circumstances that are the result of actions taken by the applicants.
Yes.
The variance request does not arise from any conforming or non-conforming condition on any neighboring property.
Yes.
The granting of the variance would not adversely affect water quality or adversely impact fish, wildlife, or plant habitat within the jurisdiction's local critical area.
Yes.
And finally, that the granting of the variance would be in harmony with the general spirit and intent of the critical area law, the regulations in this subtitle, and the local critical area program.
Yes.
Got a motion?
I'd like to make a motion in regard to case BOA 25070223 for a variance from 14.151A buffer standards and 14.152A, expanding the buffer to replace an existing deck with a screen porch, removing 2 existing sets of stairs and replacing with 1 set within the critical area expanded buffer, noting that the applicant cannot receive their building permit for the proposed improvements until the buffer management plan in accordance with Comar 27.01.09.01-3 has been approved by Queen Anne's County.
I'll second that.
All in favor?
Aye.
I now declare this hearing to be adjourned for Chapter 14 Critical Area Variances. Your building permit will be held 30 days from the date of the board's formal decision.
Thank you, board members. Have a good evening. Thank you.